please hear the worship. My name is Rachel Ihole, Assistant Deputy representing the state in this matter together with my colleagues Salam and Agosa, President Senior State Attorney. The accused is in court and is represented by Counsel that Ssegona, Counsel Samuel Muizi Mulindo, Counsel Kenneth Paul Kakande, and Counsel Paul Mchini. Your Worship, this matter was adjourned today to enable the defense make a response to the prosecution application for regulation of the media coverage in this matter.
Your Honor, for the defense, we are ready to respond to the rather acrimonious application placed before you. And we propose to proceed as follows. First, a distortion has been made in the application. The application that was placed before you was not to regulate, but to ban media coverage. And Your Worship, our principal objection is based on the following. Article 28 of the Constitution of this Republic provides in no uncertain terms in clause 1 of Article 28 that in the determination of civil rights and obligations for any criminal charge, the person shall be entitled to fair, speedy, and public hearing before an independent and impartial court or tribunal established by law. Now the emphasis for purposes of our proceedings today is on public hearing. But we shall submit that this public hearing is embedded in it the concept of fair. In other words, public hearing is an essential ingredient for a fair hearing. They are not mutually exclusive but intertwined. Your Honor, there are three principles that I agree with. The first is that it's not an absolute right. The second is that this court has the discretion to determine on whether or not to exclude media coverage or even live streaming, as it was coined. At the beginning, I raised objection against the casual manner with which this application was presented, and this is what I meant. Number one, that without a formal application, it will be difficult for you to determine the four corners of the application. As indeed you heard, the proposed ban was on media coverage, on media coverage of the proceedings. And today, Council is talking about regulated proceedings for coverage. Your Honor, the second reason I refer to the application as casual is that applications of this nature must be supported by evidence. And no evidence was presented. Because indeed, my land friend, cannot, is barred by law from having this at the bar. State attorneys are advocates. And the advocates' professional conduct regulations do not allow us to adduce evidence at the bar. So how then will she adduce evidence to justify the application if it is presented in this informal manner? So we protest the procedure adopted as incapable of arriving or helping this court in arriving at a just, fair, and reasoned decision. Be that as it may, the right to public hearing is a constitutional right which is guaranteed and established. Although the law allows the club on the exercise and enjoyment of that right, in Articles 28 and 43, there are qualifications. And clause 2 of Article 28 provides that nothing in subclause 1 of the article shall prevent the court from excluding the press or the public from all or any proceedings before it for reasons of morality, public order, or national security, as it may be necessary in a free and democratic society. So that necessity is the clause.
Can you repeat the exceptions?
The exceptions, Your Honor, public morality, morality, comma, public order, or national security. No more. Yes, please. The state, therefore, bears the duty to demonstrate, and this 28.2 should be read with 43.2. Maybe 1 and 2. That in the enjoyment of the rights and freedoms prescribed in this chapter, no person shall prejudice the fundamental or other rights and freedoms of others, 43 2C is the one of particular importance in these proceedings. And it reads as follows: and the limitations in the enjoyment of rights and freedoms prescribed by this chapter beyond what is acceptable and demonstrably justifiable in a free and democratic society, for what is provided for in this Constitution. Now,
I beg your pardon.
Article 43, public interest. 2, shall not permit, public interest shall not permit, C, any limitation of the enjoyment of the rights and freedoms prescribed by this chapter beyond what is acceptable and demonstrably justifiable in a free and democratic society. Or what is provided in this Constitution. In other words, that for you to strip the accused of the right to a public hearing, there are particular safeguards you must have into account. Oh, there are prohibitions placed on this very honorable court by the Constitution. The first is that the state must prove that the 3 ingredients in Article 28(2), which I mentioned earlier, morality, public order, or national security, one of them will be prejudiced